Hello, it's Janan Jarrah with you again for another legal informational video. This video that I'm providing today, just as a reminder, is not intended to be legal advice. So I am not speaking to you directly, telling you what to do. Instead, what I'm doing is providing information. If you do want legal advice, by all means, give my office a call and I can certainly set up a consultation with you to give you tailored legal advice. But for the purposes of this video, informational purposes only. So today what I want to talk about is the Family Focus Protocol, which is a new protocol implemented by the courts in Alberta starting in January of 2026. So starting in January of 2026, generally speaking, this applies across Alberta, but I'm going to tailor this video for Edmonton specifically. So in January of 2026, the Edmonton court instituted the Family Focus Protocol. Essentially, it is a process one must comply with in order to get their matter before the courts, should they so choose to have their matter put before the courts. So there are a couple of ways to get your matter through the courts, depending on what it's for. For example, emergency matters have their own particular type of stream and protocol. Desk applications also have their own protocol. Today's video is going to focus on regular family process applications. I'll cover the desk applications and the emergency applications in a different video. So for today's purposes, we're going to talk about the regular family process applications for anything related to family law that include things like child support, parenting, spousal support, and division of family property. So if you have a matter that you would like to bring before the courts, don't assume, absent an emergency, that you can just go to court and appear in front of a judge within a couple of days after filing your materials. Not true. You're technically not allowed to even set foot inside a courtroom if you're going through the regular family process without completing a series of steps. And this is what I want to cover today so that people know what the steps are and don't assume they can just go to court essentially whenever they feel like it. So I want to cover those steps with you today. One of the first things I like to do on a file when I'm getting it ready to engage the Family Focus Protocol is to gather financial information. Okay? Gathering financial information and exchanging it with the other party is a mandatory step. It's a required step. It's a very common step. A lot of people try to skip the step or not put enough effort to comply with the requirements, and I think it doesn't work out for them when they don't just comply properly with that particular step. So what I like to do to keep my clients, on the side of compliance is gather their financial information. And you're either going to gather items 1 through 9 or 1 through 16 in a standard notice to disclose. A notice to disclose is a document that will literally list out all of the different specific financial information that you have to provide to the other side. A notice to disclose form can be found on the Alberta Court's website. And essentially what it contains, I won't list all 16 items, but summarizing it, you have to gather tax information, bank statements, credit card statements. You have to include a Schedule A, which is a statement of income, assets, and liabilities, and any exemptions. And it also includes valuations for things like RRSPs, investments, pensions. So once you've gathered all of that information and answered questions like, do you own a corporation? Are you self-employed? These are some of the questions that come up in a standard notice to disclose. And if you follow it to a T, compile your information in an organized way, you're required to provide that to the other side. Once that's done, another step that usually has to be completed before you're allowed to engage through the Family Focus Protocol is to also make an effort to resolve your matters outside of court through either a settlement meeting, mediation, things of that nature. We call it alternative dispute resolution. So what I generally like to do first is gather my client's financial information, exchange it with the other side, review it, see if there's anything missing, and if everything is provided, the next step I usually like to do is to draft a property spreadsheet so that I can list all of the assets, liabilities, and provable exemptions that the parties are dealing with. It gives me a general idea of what an equalization payment might be once I have completed financial disclosure and that property spreadsheet. So once that is all done correctly, then I'm going to reach out to the other side and try to coordinate a meeting, a settlement meeting, a four-way meeting, in order to try to resolve any or all of the issues. And at a settlement meeting, generally how I like to run them is usually in person. I'll either invite the other lawyer and their client to my office in the boardroom to discuss all matters, or maybe I'll travel to their office for the same purpose. Once we're in the same room, we're going to cover all of the topics as much as we can. We're going to go into it with an open mind to resolution. Resolution means you probably won't get exactly what you want, but you'll settle for something closer to the middle, both sides, in order to resolve and have to save yourself from the court process, which can be uncertain because you're not deciding the outcome, a judge is, and it is a very lengthy process to get to a trial, and it's obviously often very expensive. So people really need to focus efforts where possible on resolving matters outside of court through that settlement meeting or four-way meeting. And if by chance things are resolved through that meeting, great. The parties will draft a agreement or a consent order and file it with the courts if it's a consent order, or keep it on their own file if it's a separation agreement or minutes of settlement. And if the issues are resolved, excellent. But oftentimes, all of the issues aren't resolved. Sometimes only one or two are resolved through the ADR process, and sometimes none of the issues are resolved. So what do you do at that point when you've made the effort, but it didn't work, you didn't resolve one or all of the issues? The next step then could be to engage the family focus protocol to get yourself into the family process stream in front of a judge in Edmonton. And how you do that is by filling out normally some sort of claim, an originating document, and an affidavit. The affidavit is going to detail the facts in the case. The claim is going to detail what the relief being sought is. So you have to draft those documents, plus a number of other documents that the court requires. And if you want a full list of the other documents the court requires, you can find it on the Alberta Court's website, www.albertacourts.ca. So once you are, let's say, having completed all of the forms required, including confirming that ADR is completed, confirming that financial disclosure exchange has been completed, confirming through your claim and affidavit that you have the issues identified and the facts to support it, that puts you in a position, once all those forms are properly completed, you submit them to the court. Once it's in the courts, if everything passes their requirements and you've done all of the forms correctly, then your file materials will be stamped, and then you will be required to serve a copy of those documents, the claim and the affidavit, for example, on the other party. And then you have to prove you served them by filing another document called an affidavit of service. Okay. Now, sometimes people might say, hey, Janan, but the other side won't agree to alternative dispute resolution. They won't agree to set up a four-way meeting. They've ignored my requests. What can I do? Am I going to be prevented from going to court to engage the court process? The answer is maybe not, because there is another form you could fill out requesting a waiver of ADR, or even a waiver of providing financial disclosure. So sometimes the courts will allow people to ask for a waiver of the mandatory steps when there's a good reason. So a good reason would be, for example, you can prove to the court you sent out a request to book a four-way meeting or settlement meeting and the other side refused, or the other side won't answer. Then you can tell the court and explain to them why you haven't completed ADR, and that might enable the courts to then waive your request. Now, before they waive your request, they will give the other side an opportunity to respond, to say if it's true that they're refusing or haven't provided disclosure. So they will be given an opportunity to respond. And if it is confirmed that they refuse or they don't want to participate, then a judge has jurisdiction to waive the requirement of ADR, and sometimes even to waive the requirement of financial disclosure. But as I said, those things are mandatory steps, so the courts don't just waive them willy-nilly. You have to give them a really good reason to do so. So let's assume you've completed financial disclosure, you've completed or attempted alternative dispute resolution, you have filled out all of the forms that you need, including the originating claim and supporting affidavit, and let's say all of your materials have been accepted by the court, have been filed, and they're properly served on the other side. The court will then usually provide you a date to appear in front of a judge. That date is not a trial date, it's not a hearing date, it's basically a meeting for a judge who's going to case manage you right off the bat. So you present yourself at this meeting. We call it mandatory intake triage, MIT for short. So you attend the MIT, and essentially the judge will hear what you have to say and try to help you figure out what the next step is. The next step could be that the judge says, you know what, why don't you guys give ADR another try through the courts. For example, they have JDRs, judicial dispute resolution, where it's a judge mediating the matter, trying to help you resolve. Or they might refer it to resolution counsel, which is a lawyer hired by the courts to help the parties reach an agreement. So the court, once you get to court, might encourage you to continue to pursue ADR. They might also do something different, which is set it up so that you are given a hearing date or a trial date so that the issues can be decided by a judge. Now, if you are given permission for a hearing or a trial date, oftentimes before that happens, the judge will create what we call a procedural order. The judge will want to ensure that certain steps are completed before that litigation date actually comes up. Some of the steps that might be completed would include things like perhaps updated financial disclosure or addressing outstanding disclosure issues if there are any. They will also sort out what are the most immediate matters that need a judge to resolve versus matters that can wait for, let's say, a trial, because you can do interim hearings and be given permission to do an interim hearing before a more formal, fulsome trial. So once you are in a position to know, hey, are we headed through the ADR route again through the courts? And are we going to go that route? Or are we going to go the route of litigation through an interim hearing or a trial? Once those things have been decided, don't think that you're in the clear, because there's quite a bit of work that you have to do once you're given those litigation dates, including updating disclosure, taking care of any outstanding disclosure issues. Judges will put timelines on people of when they have to provide, for example, expert reports, if that's part of the case, or when they have to provide certain disclosure. So they'll put deadlines, and the purpose of that is to ensure that if you are given a litigation date, you'll be ready to go on that litigation date. So that is a very summarized description of the family focus protocol, and for specifically regular family applications. So if you want more detailed information, because is a lot more detail to the process, feel free to go to the Alberta Court's website. Under notices to the profession, they have information. For example, I printed one out here. They have information about the process itself and what it entails. So when in doubt, if you want to do a little bit of further research on your own, go to the Alberta Court's website, look up notices to the profession, and then they will detail the family focus protocol and the requirements of it. Of course, you can also contact a lawyer to find out those details as well. And hopefully this video also helps you with that information.